I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial, Daddy.
I want to give a big shout out to the 13th Jury Podcast and Brandi.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
And then I just look to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if you're bored of work, come pop in and say, hey, we'll have some coffee.
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Hello, jurors. Hello, jurors. Hello. Come in. It's been a few days, y'all. It is, what's today? Wednesday? Today's Wednesday. It's been a few days. It's been a few days. Hello, hello. Hello, everyone. Yes, hello, hello. Good morning or afternoon, depending on what part of the universe you're in. Come on in and take your seat. It is quite a day already, y'all. Already quite a day. I have, my lips are so chapped. Look how red my lips are chapped. Because when I get to, like, when I'm working and I get, like, in a zone, I tend to bite my lips and, like, lick my lips and stuff. And I end up getting chapped lips. So anytime I have chapped lips, you can always tell that either I've been in the sun or I've been working a lot. I'm getting, what happened? What happened? I'm getting lots of love and admiration on the Tom CPU stream. Well, that's good because, I have not been getting it on Twitter. I have, only from half the people. It's been crazy. The trolls situation is real. You know, it is what it is. We'll talk about it in a minute. Pilola's mom. Choo-choo. We need a good ride. Hi, family. Thank you. Thank you for the super chat. Thank you. I appreciate it. Is Lucy? Oh, yeah, Lucy's sitting down now. Here, y'all want to see Lucy? There she is in her little... Oh, no, she hears me talking to her, so now she's got to be, like, all up on me. Thank you very much. I appreciate it. Yeah, I've been working a lot the last few days. I know that we haven't seen each other, but I've got a lot of stuff going on in the background. And, and there's just a lot going on all in my world right now. So I have not been able to see y'all in a few days, but know that I have missed you and I love you. And I have been getting some work done so that we can reunite and be back together. True Crime Ranch, thank you so much for the super chat. Thank you. I appreciate it. Thank you. And Jamie C. Binge the 5 podcast episodes, Conspiracy in Canton. I hope you liked it. Thank you. I was just telling somebody, her name is Lori. She's very involved in the Lori Vallow trial, which obviously we covered here. And she's finishing up writing her book on it. And she's super smart. I respect, her opinion a lot. And she was saying that it was really good. And I was like, well, thank you. I have a love-hate relationship with it. But, as is with all cases. I think all cases are like that, though, right? It's like a love-hate relationship with all of them. Because you want to see justice. But then there's also a lot of negative stuff happening. So, Let's see. Birdwatcher, thank you so much for the super chat. FBI files stated that Brian Albert and Brian Higgins were talking at 2:22 a.m. The wall file shows the window of Google search is 2:22 to 2:27 a.m. Cannot be a coincidence. Didn't Jen also delete a screen print text to Brian? Yes. Thank you so much for the super chat. And yes, that is what we found out. So, for those of you who missed, is my mic low? Let me see. Mic check. Mic check. Is that better? Mic check. Mic check. Maybe I should just sing. Is that any better? Maybe I'll just have to yell. Or maybe I need to move my mic. I don't know how to move my mic. Is it kicking y'all out already? Yes. So for those of you who missed it, one of the things about this case with Karen Read is that you just don't know what to believe with all of the statements being conflicting and all of the issues and all of the sides. So y'all know me. I always say data doesn't lie. So let's get to the data. But then there's a lot of debates over this data, this 2:27 a.m. timestamp. So I went to a programmer who knows about iOS coding, and asked him to explain it to me like I'm 5 years old. And he doesn't care. Not that he doesn't care about the trial, but he doesn't follow it. He's not, he doesn't have a side. He doesn't none of that. I wanted somebody who is just going to just tell me about coding. Don't explain why your side is right, because he doesn't have a side. Just explain to me about coding. So he did, and according to him, he says that there is no way around that timestamp being 2:27 a.m. So the way that he explained it, I've got it in the video. I'm not going to go over it all because it's very complicated, very technical stuff. But basically the way that he explained it is that file that they pulled it from with the timestamp of 2:27, they pulled it from a temporary wall file, and the way that iOS version of the coding is written, it means that there's automatic, they call them like checkpoints, where those temporary files, everything on those is written onto the main file. And when it's written onto the main file, that would be the latest possible timestamp. So he said that, but they do automatic checkpoints every 5 minutes if one hasn't been done within the last 5 minutes. And then they also do them if the file gets to be a certain size, or there are certain things that can trigger the checkpoint. But no matter what makes the checkpoint happen, they're no more than 5 minutes apart at the most. So if the timestamp was 2:27, he said that doesn't necessarily mean it was at 2:27. It would mean it's sometime between 2:22 and 2:27, 2:27 being the latest. So that was the technical breakdown for that. So I went through all this trouble to do that. And of course, everybody who doesn't want the timestamp to be at 2:27 is now attacking me. Comes with the territory, I guess. Chrissy Bacon gifted a membership. It went to Rona. Rona, welcome. Welcome, welcome. Where'd that go? Oh, there it is. Yay. Chrissy Bacon, thank you so much. Thank you. And Anne, love Brandi and Lucy. We love you too, Anne. Happy 4-month anniversary. I know it's kicking everybody off already. I don't know why. Sandra Oliver, member for 10 whole months. Where'd it go? Everything. Oh, I'm having issues here. There we go. Member for 10 whole months. Happy anniversary. Happy anniversary. Happy anniversary. Yeah, it's just noise. The thing is, I have said over and over, I don't know what happened. I wasn't there. my issues have been very much like with the investigation, the way that things were handled, all the stuff that's like conflicting. There's a lot of questions. So, but people are very aggressive over this one. Be kind, tiger. Where'd that just go? There it goes. So excited to see you and everyone. 10 whole months. If you are excited as I am to see Brandi, smash that like button and show her some love. Thank you so much. Thank you, thank you, thank you. I appreciate it. Thank you, thank you. Yeah, it's been it's been something. You know, the thing is, there are things that I have said in the podcast and on the show that go directly against both sides. And the way that I look at things, I've been very clear that like there's a lot of things that are really wrong with the way that the Commonwealth has handled things, the way that Morrissey has handled things, the way that the state police handled things, the way the judge, I'm not a fan of hers. Like, I've been very clear about, you know, about all of that. Now, when it comes to not the people investigating and the people carrying out the case, but when it comes to the actual people involved, I keep saying the problem is we don't know if all of these conflicting statements are from the witnesses changing stories, which, I mean, is possible, but also if you look at the time frame of these statements, none of them were recorded. So we don't know that it's the witnesses. We don't know that that it's not the, you know, yet another issue with the law enforcement and the investigation. That's the biggest problem. Get your words together. I've been up since 4:30 a.m. The interviews not being recorded, and, you know, they don't have, like, you know, detailed notes and stuff. That is a problem when you then are looking at all these conflicting statements, because you can't go back and say, oh, I wrote this down wrong in the report, you know? Think about how many, you know, issues we've seen in trials where they were able to catch some kind of detail in a recording. So, you know, it would have been a lot more helpful for that. And then you have like the argument over the data, and there's conflicting data. I went over this before, you know, like the health data and the GPS data go directly against each other. So it's going to come down to, you know, accuracy of both, and what you believe is more reliable, and what theory you think works. So, you know, the jury's going to have to make up their own mind. It's it's quite a case. It is quite a case. But the good news is that, you know, trial is coming, and hopefully it'll all come out, and we will maybe have some questions answered for once, instead of just bringing up more questions. Let's see. I have an unpopular opinion on this case, but I don't feel the need to be a jerk about it. I don't understand some of these people. Yeah, you know, whichever your view is going to be unpopular with half of the population. So, but that's my thing, is that, like, you know, like, why do people need to, like, why do we need to throw tantrums? Who knows? But you know what? At least people are passionate about it, so that could be a good thing. Stacy S., where did this... Stacy S., I'm trying to show your anniversary thing, and it just jumped again. I keep having issues here. Daisy, yes, where'd you go? There it is. Found it. So glad to see you. Brandi and Miss Lucy. Good afternoon, everyone. Good afternoon, Stacey. Yes. Happy 8-month anniversary. 8 whole months. 8 whole months. And Lady in Gray. Maybe it's because I've been up so long in my... Oh, my broadcast on Twitter has apparently got the wrong information. Fun times. All kinds of tech issues. Lady in Gray, I thought I was 10 months last month. Time flies. Time does fly. Time does fly. I'm glad you're here. Happy 10 month. 10.2 month, maybe. 10 month times 2. I'm glad to hear. I'm glad you're here. Yay. Thank you for that. So I will show you what we're working on. Now, I will say this, while we're doing the hearing today, everybody in here is welcome, whichever, like if you have chosen a side, you are welcome. If you have not chosen a side, you are welcome. If you don't know anything about it, you are welcome. But big rule, don't be a jerk to anybody else. Everybody's allowed to agree, to disagree, agree, love each other, dislike each other, do whatever you want, but no being mean. No being mean. It's my only rule. One of my only rules. The on the fence here, a lot of people that are on the fence are, I have noticed, are scared to say anything, because if you're like me and you're pointing out issues with both sides, then you get, pummeled. And thank you for the super chat. Thank you. All right, I'm going to streaming. There we go. All right. Oh, look, this is episode 6. It's coming. We're working on it. We're getting there. I want to show y'all. This is what I've been working on. One of the things I've been working on. The timeline is one of the things that has been, y'all know how I am about a timeline, but the timeline is one of the things that has been very, sketchy in this. There are some things that just don't line up. There are things that don't make sense. There are some things, especially in the statements, that don't line up with the data that we have. And some of it's just kind of hard to grasp based on how many different stories there are. So I have been working on doing the interactive timeline. So I'll show you. Crime line. Yes, crime line. I like that. So everything's interactive. So you can kind of scroll through. There's 2 different timelines right now, and I'm still finishing it. Everything's done pretty much up until the time that Karen leaves 34 Fairview. Everything else I'm still kind of adding in. I'm trying to do this on top of doing the next episode for the podcast, on top of some other meetings that I've had in between. So everything has been kind of crazy. Court is supposed to start in about half an hour. So it starts at 2 Eastern. So I started a little bit early so we could go over some of this stuff. Welcome to the family. Welcome. So this is all on 13zeropodcast.com, but if you want to take a look at some of this, and we'll have, I'll have it all completed by the time we go into trial. So that way, as we're watching the trial and, kind of hearing everything and going through all the evidence, we'll have all of this to use as a reference and kind of compare everything. But everything's kind of like an interactive timeline. So everything's broken down into different sections. So you can scroll through like this, kind of clicking on different things, or you can start at the beginning and just scroll through. So I've got everything like with pictures and all that, like the bar hopping begins, who arrives at what time. They're all at separate places as people are arriving. I've got all that information. When they join together, then everybody's at waterfall and who's, what times and all of that. So some of this is based on, and it'll say in here where the times came from. So some of it's based on the phone data, location data. Some of it's based on statements. Some of it's based on camera footage, different things. So but the problem is so much of it is conflicting. So that's why I wanted to do the timeline, so we can kind of figure out, look, witnesses are always going to have some kind of, like maybe you say like, oh, I was there until about 1:00. And then another time you say maybe 1:30. And maybe the reality is you left at 1:17. Like there's always going to be that kind of stuff. That kind of stuff isn't, like, I've made notes of it just so that we have the notes of it, but that stuff isn't really the stuff that I look for when I do these. It's the stuff that's like, that's way off, or like in some of these cases, it's like, one of the things that I found so interesting were in all of the original first, I think, 3 statements, it says that Jen McCabe, and again, we don't know if this is Jen McCabe saying this or if this is the reports, but in the first 3, it says that, Jen McCabe saw Karen leave, like saw her drive off. And then in the final statement, her final interview, it said that she didn't see her drive off, that the next time she looked out the window, the car was gone. So it's stuff like that. Looking at stuff like that and what changed and when it changed and that type of thing, trying to figure out, what's just, what's important and what's not. But also the most crucial minutes are, of course, those few minutes when when Karen is in front of 34 Fairview, because that's the time then that they say that she hit him. So it's got all of this second timeline is just a breakdown of just those crucial minutes. And if you scroll to the end, I think this is, the latest Karen could have left was this time. So if you scroll to this one, you can click on this, but this has got all of the evidence that goes for both sides. So there's some evidence that supports the Commonwealth theory. There's some evidence that contradicts the Commonwealth theory. Some of the stuff that contradicts the Commonwealth doesn't necessarily support the defense either. So it's one of those things where you just kind of have to kind of look at everything and come to your own conclusion. I think that there are so many issues with the that reconstruction that they had in the last information, like the last before I had to take my little medical hiatus. That reconstruction theory that they had, it didn't fit with anything. It didn't make sense. It didn't work. So the Commonwealth had presented that as, their theory, and now that's just kind of like left out. So they have, I'm assuming, will give us new theories, new timestamps, new information that actually does work. But this is all based on the most, the one that they had before they kind of started, getting rid of it. The problem with that one was, their time of impact, where they say that she hit him. There were witnesses that were parked like right behind her. The way that the reconstructionist said that she would have had to have hit him, isn't logical and didn't make sense. There were a lot of issues with it. It was pretty easy to debunk based on just the data alone. So they've taken that one out. So we'll have to see what their newest theory is. I think one of the big things with this programmer who was like a programmer and coder who was kind of breaking everything down about this whole 2:27 a.m. search is, let's say that Jen McCabe has nothing to do with anything, would the jury be able to find a logical explanation to be searching that at 2:27? If they get somebody in there that explains, like the way that he did to me, this is code, and there's no arguing with this. Is there another explanation that they'd be able to come up with? So it'll be interesting to see how a lot of this, comes out in the how everything comes out. It's one of those situations too where if only the investigation would have been done properly, the police reports would have been done properly, things wouldn't have been so shady, I think there would be so much better information, fewer questions, less issues. But, that's not what we're working with. Rick Hamels, I thought someone, maybe Melanie Little reached out to me. She wants me to come on. So I told her that I will work that out. We're going to find a time. I'm going to go on her show. It showed that Ryan Nagel was behind her for about 5 minutes. Yes, and that one's on here too. Let's see. So all this, like this time right here, this is in here too. I've got all this in here too. Ryan Nagel, Richie, and Heather were parked behind them. And that's during that time where they said that in that original reconstruction situation that she would have backed into him and hit him, which is just it just isn't possible. Everything else contradicts that directly. So we'll see what they come up with next. But yeah, I mean, to say that they would have been parked right behind her and not seen her drive up 62 feet and then back 62 feet and then keep going over him and then pull off, it's just not possible. So, motive either side. That's an interesting question too, because according to the theories, Commonwealth is saying that her and John, got into a fight and, were fussing and arguing and all that. My thing is, she called him when she got to his house, and she even called, she did that whole, drunk, angry girl phone call thing where she's calling him and leaving him voicemails like, I hate you. And if you just killed somebody because you're, mad at them and want to run them over, it doesn't make sense to call and leave voicemails saying, I hate you. So that doesn't really work out. The defense's theory that they outlined was that that there was a fight that broke out, possibly, drunk, got out of hand, fight, and went too far. That's their theory behind it. So, yeah, there's a lot of things that are untucked, stuff that just isn't clear cut, and I'm not sure how they're going to make it fit. That's the thing, is that, and I said this in the podcast too, neither theory fits 100% into everything. So they have some stuff that they're going to have to try to explain. Melanie believes the scratches on his arms are dog bites, and I tend to agree. That is a very widely accepted and debated issue. You know, the injuries on John, it just doesn't look like getting hit by a car. So, if you remember, we watched the hearing where the defense held up the picture on the poster board thing, and we're saying, this is dog bite. And I've seen, there are different people that have, like medical professionals and stuff that have come on different shows and said, yeah, that's consistent with dog bites. I should have gotten more sleep. So that's one of the things that they're going to have to battle out too. And that's one of those things too, that they're going to get into trial, and you're going to have one expert on one side saying one thing and another expert on the other side saying another thing. And the judge will give that instruction, like, expert opinions are giving their opinion, and it's up to you to decide how much weight you put on each one. So, they'll decide the jury will each decide what makes the most sense to them. I don't think it looked like dog bites, maybe scratches. Yeah, I might have said bites. I'm going on 3 hours of sleep. But yeah, like they said, I've heard a lot about the, like scratches and like the, that it being fang marks and stuff like that. And then the other side says that it's from getting hit by the car. I am feeling pretty good. I'm just tired, but it's good. My energy levels have balanced out a good bit though since I've quit treatment, so that's good. Yeah, this is one of the things that they're debating too. The state says that there was no dog DNA on the arm, but they didn't test the tissue. I think is like they tested for dog DNA on. Don't quote me on this. It's on my notes of stuff, but I think they didn't test the tissue on the arm. They tested on the clothes or something. I'd have to go back and check. I have on one of the upcoming episodes, I have everything lined out where I'm going to go over like all the additional evidence and how both sides see it and explain it. Jennifer Coffin-Duffer doesn't like anybody. Okay, so let me pull this. Oh, they're, oh, here.
They smashed it out of my hand.
Who smashed it out of your hand?
One of the freaking McAlberts. I don't know which one it was.
They're out there
Keep going so I can go on and rewind it.
protesting.
How long ago was it?
It's 5 minutes ago, not even.
I don't know. They knocked his phone out of his hand and smashed it. They, oh, shit. It was broken up.
No, I'm having issues. Let's see. Let me see if I can pull it up over here. I am also waiting to hear more about, of course, the internal investigation against Trooper Proctor, which was announced, almost a week ago now?
When the clerk comes up, you can ask. I'll put him on here for now, but just ask him.
They're outside there. So there's a big group outside of the courthouse. Anytime she's down right here, she's usually watching seagulls or Lucy likes to bark at the spring breakers who are doing TikToks. When they start dancing and stuff for the camera, she gets really mad. She doesn't like that. Lucy does not like TikTok. She's kind of like her mama. But would he have dog DNA on his arm after being in a snowstorm? That would be... I guess that would, I am not a medical person. It would be kind of... I would think if it's bites, maybe it would be in there, but if they didn't test the tissue... go back and look. Having these few months off to go through treatment and stuff, I kind of kept up with stuff a little bit still, but trying to catch up after being away has been talk to a dog bite expert. I looked at pictures of severe dog attacks and it looks like his injuries. I've heard that from a few people. This is supposed to be the last one, I believe, before the trial starts. We'll find out if, trial's going to be delayed. Oh, I'll have to look. I haven't checked my DMs. I've been working so much. I know I haven't seen y'all because I haven't done a live since Thursday. But I have been so busy. Okay, is that any better? Or no?
Your head is beautiful. We're gonna love the back of your head. We all just stare at each other.
don't you send them the other side of town? I'm both Cal.
Great, thank you.
Hi, how you doing? Fine. Hi.
I'm sure. Oh, I don't know. Usually it's just one of them. They're usually not both there, right?
Email them again.
Yannetti, California attorneys, are they going to be on Zoom?
They'll be on Zoom, but they won't be arguing.
Okay. Oh, he was here earlier. He's Greg Henning. Can you make on the Zoom?
Do you want to be on Zoom?
Not really.
Okay.
Hello.
Hat off, sir. Sir, take your hat off.
The code for it has. Thank you.
Okay. The other one. is that I don't have anything written, but it's just based on this. Gotcha. I understand.
I guess she's signed to Dedham District now, Martha. So you could always just call her if it's not. Right. Well, I'll catch up on.
Motion to feature? I don't have that. slides. Thank you.
Can you hear me now? It's not letting me use my regular microphone. I had to put it on my camera microphone.
Just remind the folks about the cell phone use, okay? About the radio, no cell phone, no matter, okay? Taking those cell phones, go off first, and go up first. What should you do?
Roll.
We're going on the record.
Officer John, why don't you come upstairs?
All rise for the court, please.
Here we go. Does this sound weird on my mic? I can't use my regular mic. I thought Lucy.
Now, what we need,
Good afternoon, Your Honor. We are on the record on Commonwealth vs. Karen Reed on docket 22 CR 117, beginning with the ADA. Can we have the parties state their appearances, please?
Adam Lally for the Commonwealth. Good afternoon, Your Honor.
Good afternoon, Mr. Lally.
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Ms. McLaughlin.
Good afternoon, Your Honor. David Yannetti for Karen Reed. With me is my sister, Attorney Tanis Yannetti.
Good afternoon, Mr. Yannetti. Good afternoon, Ms. Yannetti. Good afternoon, Ms. Reed. Okay, we ready to start? All right. So what I'd like to do, the order I'd like to go in is, first of all, the Rule 17 motion regarding Trooper Proctor. So we did receive, and it was docketed today, an appearance of Attorney Michael DiStefano. And in his response to the defendant's motion, he tells us that Michael Proctor does not object to the defendant's motion for an order pursuant to Rule 17, seeking records from the Mass State Police Internal Affairs Division. So he doesn't object to that, so that motion's allowed. Any comment, Mr. Lally?
No, Your Honor, I would just say that the Commonwealth also does not object. Spoken to legal counsel from State Police, they do not object. Whatever limited materials are available at this time have already been provided to counsel for both sides, with the recognition of an ongoing obligation to provide materials as they exist. So no objection to that being allowed without objection.
All right, so that's one done. The second motion that I'd like to start with is the defendant's motion for Rule 17 directed to Kevin Albert, Brian Higgins, and Brian Albert. Before we begin on this, Mr. Lally, is the Commonwealth opposed to either of the other two motions? Just a yes or no? And
Yes.
okay, and do we have third-party counsel here on either of these objecting?
Yes, I believe so.
Okay. All right. So I'll hear from you then, Mr. Yannetti, on your Rule 17 motion, seeking records from April 23rd to the present.
Thank you, Your Honor. With regard to this motion, Your Honor, Brian Albert was served with a subpoena to testify before a federal grand jury, and he begins reaching out for Brian Higgins. Brian Higgins testified to the federal grand jury that he stopped taking Brian Albert's calls. He stopped replying to Brian Albert's text messages. It's fair to say that led to a panic in the Albert family. We learned that Brian Albert contacted his brother, Canton Police Officer Kevin Albert, to intervene.
I'm actually going to stop you there for 1 second. Mr. Lally, is Kevin Albert a Commonwealth witness?
No, Your Honor.
Okay, I just wanted to clarify that.
Now, bear in mind, Your Honor, that the Canton police were supposedly conflicted out of this case at that point.
So I want to know where that is in the record before me, because I think you know, as Massachusetts counsel, that the state police have jurisdiction over homicides, correct?
Oh, they do, yes.
So where is it in the record that they were conflicted out?
Those are in reports that the prosecution provided to us. Mr. Lally also told me that orally early on in this.
Okay, so I need those reports. I need that reference.
Okay, we're happy to provide that, Judge.
Okay, so I'd like it by tomorrow morning.
That's fine, Your Honor.
Okay.
So the Canton police had a conflict precisely because Kevin Albert is an officer in their department. So how can they conduct an investigation which includes the brother of one of their officers? It stands to reason they can't. They appeared to recognize that. Yet Chief Berkowitz is talking to witnesses in this case, and Kevin Albert himself inserted himself into this case. Brian Albert testified to the federal grand jury about the fact that after Brian Albert received a federal grand jury subpoena, Kevin Albert contacted Brian Higgins. Kevin Albert said to Higgins, and I quote, "Look, you went off the grid and Brian doesn't understand. You haven't called him, you haven't checked in on him since these subpoenas go out. Everyone got a subpoena but you." Those were Kevin Albert's words to Brian Higgins. And Your Honor, there's only one way to interpret that. Brian Albert was panicked that Brian Higgins had flipped on him. Brian Albert enlists his Canton police officer brother to contact Higgins to try and find out if that was the case. And it wasn't just text messages between them. After first testifying that he didn't want to talk to Kevin Albert about the investigation, Brian Higgins later admitted that before he testified, before the federal grand jury on June 1st of 2023, Higgins and Kevin Albert talked on the phone for a good 15 minutes. That was 2 days before he testified before the federal grand jury. Before he testifies to the feds, Brian Higgins is conferring with Kevin Albert, who's supposedly conflicted out of the case. So, you know, my goodness, with all the allegations of witness intimidation thrown around by this DA's office and special prosecutors they appoint, why has Kevin Albert never been investigated for witness intimidation? And for that matter, why has Brian Albert never been investigated? But as you ponder those questions, please realize, Your Honor, we're not asking for much here. We're only asking for relevant phone records. We're asking for contact between Kevin Albert and Higgins and Brian Albert. We're asking for contact that violates the recusal, the self-recusal of the Scranton Police Department from this investigation. Contact which impeaches them, contact which is relevant to their motives in this case. It impeaches the investigation. We are entitled to explore whether this investigation was conducted correctly and ethically. And we're entitled to explore whether improper influence was put upon witnesses by the Alberts. Without this testimony, this federal testimony from Higgins, and without the federal investigation, we never would have known of Kevin Albert's involvement here. But now we do. And the Commonwealth does. Why aren't they curious about what was said and why? They've announced an objection to this motion. Why are they fighting our quest to get exculpatory evidence? We need this evidence, these phone records, in admissible form. That's why we're filing this Rule 17 motion. We have more than met the requirements of Lampron. The records are relevant because they tend to show a cover-up. They are relevant because they show a Canton police officer inserting himself into a case in which his department was conflicted out precisely because he was an officer there. They're relevant because they impeach the credibility of Commonwealth witnesses who deny that they are a part of a conspiracy, yet the phone records tend to show they were conspiring together. We cannot get these records any other way. We cannot effectively prepare for trial without these witnesses.
So you testified as to their relevancy. How are they evidentiary?
They're evidentiary because they are both relevant and material, and if they're provided by the providers with an appropriate affidavit from a keeper of records, they're admissible. The Commonwealth could have gotten these records at any point, but they chose not to. And they have fought our efforts to get all phone records. Thank goodness another law enforcement agency stepped in and did the job that the DA's office should have done but did not. We need these records. Going to trial without them would violate my client's rights to exculpatory evidence. It would violate her due process rights. And finally, to the extent that this court previously ruled that our requests for phone records were a fishing expedition, nobody can claim that anymore with a straight face. We now have testimony that these records exist, that calls exist, that text messages exist. As Mr. Lally said in the last hearing, phones do not lie. These phone records do not lie. We need them, and we ask the court to order them.
All right, it looks like you're asking the parties themselves to bring these in, though.
To the extent that they have them, that's accurate, Your Honor. We're also asking for their phone providers to provide them as well.
They're two separately filed motions, right? And
yes.
One of them is with Mr. Berkowitz, or former Chief Berkowitz, but he's not on the other. So I saw them as two distinct motions, and the one that we just heard you on, is really asking them to deliver whatever records, right?
Correct. And I would note that the providers are on the second motion, except for...
But that's three different people, or one different person on the second
One different person. So we have Higgins and we have Brian Albert on the first motion. We have Higgins and we have Brian Albert on the second motion. The difference is Berkowitz versus Kevin Albert.
Right.
Right.
Okay. All right. Mr. Lally, I'll hear from you, and then I do see Mr. Henning here. I don't know if he wants to speak or not, but I'm going to hear from Mr. Lally now.
Your Honor, just very briefly with regard to this motion. With regard to the Rule 17 motion with request to records or communications from individual cell phones from April 1st of 2023 to the present day. Firstly, the Commonwealth would just indicate the facts as recited in the defendant's motion the Commonwealth would submit are largely inaccurate. It's injected with hyperbole, injected with conjecture, in regard to federal grand jury materials which belie much of what counsel claims that they say. Essentially unsubstantiated conjecture, which is directly contradicted by the testimony and the evidence contained within the federal materials. Now, I know that the court has had those materials and has carefully reviewed those materials, so I don't feel the need to go into each and every specific ground. However, what I would say is, secondly, even assuming that everything contained within counsel's motion was true and accurate, the defendant's motion in this specific instance fails on two grounds. Number one, what the Commonwealth would submit is that the time period that's being requested is far too overbroad for whatever collusion or whatever purportedly occurred, according to counsel, going from almost a year worth of communications from people who, admittedly, through the testimony and through the evidence that was presented and has been presented in both forms, knew each other well and knew each other well before any of this occurred and continue to associate and be friends following this incident. Secondly, the sort of last paragraph of counsel's motion claims that the records are needed to establish the exact nature and extent. What the Commonwealth would submit is really what they are needed for from counsel's perspective, is to establish the existence of these conversations and what the content of them were, which is the very epitome of a fishing expedition. And so for those two reasons, the Commonwealth would submit that the defendant has not met the standard under Lampron, and that motion should be denied.
All right, so I see Mr. Henning, so I don't know, do you want to be heard? Yeah, please come forward. And I don't know who counsel is for Mr. Higgins, but if he or she's here, do you want to be heard as well, sir? Great, so I'll hear you after I hear from Mr. Henning.
Good afternoon, Your Honor.
Good afternoon.
On behalf of Brian Albert, I just wanted to put three things on the record for the court. The first is, and I'm sure the court is aware, that the parties that are the subject of the Rule 17 motion have not actually received the motions. We got the cover page, we got the orders and the proposed orders, but we have not been able to review the actual memoranda because, at least according to the interpretation of the protective order, we're not entitled to see that content. And that...
All right. I ruled that they were to be given because the federal proceeding is not to interfere with this court's proceedings.
I understand that, Your Honor, and I did receive the court's order, and I informed each of the respective counsel that I spoke to as far as what the court's order was. And I also understand that the court hasn't had the opportunity to review the federal protective order, but my interpretation of that order simply would not permit dissemination of the material contained within the memorandum.
Even though the Lampron Protocol says shall, doesn't that supersede a federal protective order? It's the law of the SJC. How can third-party record holders, the people who Rule 17 in the case law protects, not be able to go forward without it?
And I understand there's a direct contradiction there. And so, out of an abundance of caution...
Okay, no, I understand you're following your order. I'm going to make it available. Not a party to any protective order. So we can take a recess. You can have them now. What do you all want to do? I mean, I didn't know that the Commonwealth was not complying with my order. I understand why you didn't, but I didn't know that.
My apologies.
I'm happy to be heard now, and if the court will allow us to review the motion and the memoranda, we can amend with a written filing if there's something that we need.
Yes, pursuant to a protective order, the way we have them in the Massachusetts courts for Lampron Dwyer records.
Okay.
So,
Can I have one moment, Your Honor?
yes.
Her saying she didn't know that Commonwealth wasn't complying with her order, I think that's the first time I've heard her kind of get on Commonwealth in a bit. So all of this is the Rule 17 motion.
Your Honor, what I think the counsel for the third parties would ask is that we are able to address the court today, but allow us an opportunity to review the memoranda and submit something in writing before the court makes an order.
Sure. I'm just rereading the appendix on Dwyer, and it is a shall. So my view is that the SJC in Commonwealth versus Dwyer, the procedure that we're to follow, allows certainly, and I say mandates, that the third-party record holders be given this information. So we will provide it when we take a recess today. I'll ask Mr. Clerk to make copies of what I have, not what the lawyers have. We need protective orders signed before you're given them. And I will have them given to all three record holders, or four if there's somebody here from Mr. Berkowitz. All right, I'll hear you.
Thank you. The first part of what I wanted to address dovetails with what Your Honor is just addressing. The fact that we are third parties in this matter and do not have access to the materials that are in the subject of the discussion from the federal side of things makes us at a disadvantage here in front of the court. Obviously, we're going to remedy that, hopefully, by being able to review it. But that notwithstanding, the fact that there is materials that we can't review that are being discussed in front of the court, even if we are able to see the memoranda, makes it difficult to address these. And I think for an issue of fairness, I want to make sure that the record's clear. If there are future motions, I want to preserve and not waive any argument as to the fairness of being able to access those records. So that would be the first point. The second point is, going into this, not having an opportunity to review the record, I do believe that the Rule 17 standard of relevance still needs to be met regardless of whether we get to see the material or not. So what I do want to offer to the court to consider as part of your determination here is that after receiving the notice from the Commonwealth last week, I contacted the U.S. Attorney's Office and I spoke to the lead prosecutor in the case.
Okay.
What I want to have the court know is that I have permission to notify the court that Brian Albert, his wife Nicole, his son Brian Jr., and Caitlin are not targets of the federal investigation. And I've been given permission to disclose that in open court.
Okay.
So I think it's important for the court to know that as you go into the motion that you're considering and the arguments from the defense. The third thing I would like to just ask the court is, notwithstanding everything that's just been said and reserving the right to file that written document later on, Brian Albert does not object to turning over the materials that are being requested. I understand that the Commonwealth may be having objections as to the Commonwealth's case, but Brian Albert does not have anything to hide. He does not have anything that he needs to prevent the court from seeing this material. And if the court does deem, after reviewing the material and having access to the federal records, that these are somehow relevant or that these are somehow admissible, and the court deems that Rule 17 has been satisfied, Brian Albert will comply with the court order.
Thank you very much.
Thank you.
Great.
On behalf of Kevin Albert, present is Peter Paschuko, and on behalf of Brian Higgins is William Connolly.
Great. Thank you. All right, so counsel, I need you to spell your name for me, please.
Yes, Your Honor. The last name is Connolly, C-O-N-N-O-L-L-Y.
And what's your first name?
William.
Thank you. All right, I will hear you on behalf of Mr. Higgins.
Thank you, Your Honor. Your Honor, as the court is aware, Brian Higgins' phone records and communications are at issue in these motions. Brian Higgins is a federal ATF agent. He is a witness in the Commonwealth's prosecution of this case, and he has cooperated fully in the Commonwealth's investigation. As this court knows, we've not had the benefit of seeing the factual support for these motions, but I want to provide some information that likely isn't contained within those materials submitted to the court but of which I have a good faith basis to believe is information contained in the materials provided by the federal government to the parties in this case. I have represented Brian Higgins since April of 2023, the month when he received the federal grand jury subpoena. Like he has in this case, Brian has cooperated fully with the federal investigation. He has answered every question put to him in both investigations, and he will continue to do so because he has nothing to hide. Brian Higgins is not a target of the federal investigation. That has been confirmed by the United States Attorney's Office and confirmed to me that I could make that representation in court. The U.S. Attorney's Office has continuously confirmed throughout its investigation that Brian Higgins is not a target of their investigation. Brian Higgins has not participated in any kind of a cover-up or conspiracy to cover up the criminal activity of others. Brian has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a congressional medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq. Participating in a cover-up is contrary to who he is as a human being and a professional. I am here to represent Brian's interest in privacy. Brian Higgins, at my urging, will not capitulate and stand down when efforts are made to further intrude upon his privacy based upon sheer speculation. It is for that reason that we oppose these motions, not because Brian Higgins has done something wrong or has anything to hide. We know this court will give us an opportunity to review the motions and supplement our remarks if we deem it necessary. We know this court will fairly weigh the arguments before it and will render a fair decision, and we will respect that decision and we will comply with that decision. Respectfully, we do not believe there is a sufficient factual basis to support the relief requested in the motions before the court. Thank you, Your Honor.
All right. Thank you very much. Counsel?
Brian Higgins is the one who left, said he left at 1:30 to go do administrative work at Canton Police Department. He'd been there earlier.
Good afternoon, Your Honor. Attorney Peter Pasciuco on behalf of Kevin Albert.
All right, so you need to spell that last name.
Sure, it's P-A-S-C-I-U-C-C-O.
Good afternoon.
Thank you, Your Honor. Just a little bit of background with respect to Mr. Albert, and we are objecting to this Rule 17 motion. Kevin Albert's a 19-and-a-half-year veteran of the Canton Police Department, extremely well-respected, extremely well-liked. Any insinuation that he participated in a conspiracy or cover-up is simply untrue. There's been no showing how personal communications between my client and Mr. Higgins have any relevance here, let alone evidentiary value. Kevin Albert is not a Commonwealth witness. He did not testify in the federal grand jury, and his involvement is essentially zero. This is a clear intrusion, as Attorney Connolly indicated, into the privacy rights of these individuals. And I've advised Kevin that there is simply no reason to acquiesce to something that's just clearly a fishing expedition. So upon my advice, Kevin Albert is objecting to this Rule 17 motion, but we will honor and respect the court's decision and appreciate the time to supplement any response in writing after we see the motion and affidavit, which hasn't been provided to us yet.
Okay. Thank you very much. All right, Mr. Yannetti, did you want to respond or no?
No, I would just move to the next motion if the court were ready.
Okay, so we'll move on to the next motion. Mr. Lally, you didn't want to add anything, did you?
No, thank you, Your Honor.
Okay. All right, so this motion concerns Brian Albert, Kenneth Berkowitz, Brian Higgins.
Yes, and Your Honor, with the court's permission, I'd like to start with Brian Higgins with regard to this motion.
All right, so Mr. Lally, is it safe to assume you did not provide or you didn't comply with my order in providing the motions and supporting affidavits on this as well to the third party record holders and their lawyers?
Yes, Your Honor.
Okay. So the counsel will receive copies of this as well and be permitted to argue now and supplement it.
We'll do a poll.
All right.
Thank you, Your Honor. As I previously mentioned, Brian Higgins did testify before the federal grand jury And at that time, he was specifically asked if on January 29th of 2022, he made any phone calls when he got home. He said that he did not. He testified that he lived alone. He testified that he was alone that night. He testified there was nobody else in his bedroom. He testified that when he went to bed, he placed his phone on the bedside table. After making those admissions, he was confronted by a federal prosecutor with his phone records. Those records revealed that Brian Albert called Brian Higgins at 2:22 in the morning on January 29. Those records reveal, moreover, that 17 seconds later, Brian Higgins called Brian Albert back, and that call lasted for 22 seconds. Now, when he was first confronted, Brian Higgins first tried to claim that it had to have been a butt dial. That term butt dial is used by many of the Commonwealth's witnesses to explain the many calls between them and among them. And I've never seen a case where there have been so many butt dials, to be frank. But Mr. Higgins was already locked in. He already testified his phone was on the bedside table. His butt was in the bed, the phone was in the table. The two could not have met, Your Honor. There was no possibility of a butt dial. And then Higgins admitted that. And that wasn't Mr. Higgins leaving Brian Albert a voicemail. He also admitted under oath that the toll records would have reflected a voicemail if they went to voicemail. He admitted that to call Brian Albert back, he would have had to first reach for his phone, then unlock it with the passcode or Face ID. Then he would have to press on Brian Albert's number. And that is exactly what he did. And he testified that that was what he did. He also testified that nobody from the Commonwealth, not Trooper Proctor, not ADA Lally, no one has ever asked him about that phone call from Brian Alberts to Higgins, or the return phone call from Higgins to Albert lasting 22 seconds. Rather than get everyone's phone records, as this court knows, the Commonwealth has fought the defense at every turn in our quest to get the phone records. They've persuaded this court that we were previously on a fishing expedition. To the extent the court once thought otherwise, it is clear this is no longer a fishing expedition. We do not have to go fishing to wonder anymore whether calls were made. We now know that someone who had been in that house when John O'Keefe arrived called the homeowner at 2:22 in the morning, 3.5 hours before John O'Keefe's body was found on the homeowner's lawn. We learned that neither party to that call ever revealed to police, investigators, or prosecutors that they connected by phone in those early morning hours. Just like Jennifer McCabe never revealed that at around the same time she was Googling, asking how long it took for someone to die in the cold, a search that the FBI confirms happened at 2:27 in the morning, again, about 3.5 hours before John O'Keefe's body was found. Now, for his part, Brian Albert also first tried to claim that his phone call to Brian Higgins at 2:22 in the morning was a butt dial. He said that he was awake and watching TV, but he was called back to the grand jury to testify a second time. The second time, Brian Albert changed his testimony to say that at 2:22 in the morning, he and his wife were in bed in an intimate situation. He claimed that he had his phone with him in the bed. So now he's claiming that it was during that intimate situation with his wife that he supposedly butt-dialed Brian Higgins. He had no explanation, however, for how his phone picked up when Higgins called him back 17 seconds later. He had no explanation for the 22-second phone conversation that followed, and it's worth noting that Higgins testified he never heard any intimate noises on the other end of the line either. Brian Albert tried to maintain that he butt-dialed Higgins, but again, that would mean that his butt also answered the phone when Higgins called back, and it doesn't make any sense. Both men denied talking to each other despite being confronted with that mountain of evidence by federal prosecutors. But it wasn't just the January 29th, 2022 calls between Higgins and Albert. Brian Higgins' phone records, we learned, reveal that Canton Police Chief Kenneth Berkowitz was involved in interacting with both men shortly after John O'Keefe's body was found. And again, recall they're supposedly conflicted out of this case.
So I'm going to, there's just a question I have, and I'll let you continue, Mr. Yannetti, but regarding the dates. So the dates of the records you're seeking
January
for Brian
29th.
Albert, so January 29th to February 4th.
Or 4th or 5th, yes.
4th.
4th.
That's what you're
That's
seeking.
fine. That's fine.
And for Kenneth Berkowitz, January 29th to February 18th, and Brian Higgins, January 29th to February 18th. I need you to explain to me why those dates, why
Right, so-
February 4th and February 18th.
There was testimony in the federal grand jury that Berkowitz and Higgins were speaking to each other up through the 18th. With regard to Mr. Albert, we had evidence through the 5th.
All right, it's not entirely clear from the affidavit. Okay. All right, so go ahead. Thank you for answering that, and I'll hear you. Go ahead, continue.
Right. So as soon as John O'Keefe showed up deceased on Brian Albert's lawn, Canton Police decided it might not be a good idea for them to be involved in investigating this case. And by the way, I'm reminded when I sat down that District Attorney Morrissey announced that publicly. So we knew that early on.
Okay, so is that in his statement that I've had copies of?
It is not in the video statement that we moved to sanction him for. It was a previous statement that he issued.
All right, so get that to me, okay?
That's fine, Your Honor. So the question is, why was Chief Berkowitz inserting himself into this case almost immediately? United States Attorney Joshua Levy questioned Higgins about that in the federal grand jury. He summarized the phone records in their possession, records the feds have that we do not, records we're asking this court to order so that both parties in this case can review them. Mr. Levy directed a question to Mr. Higgins in the grand jury where he asked about all of the back and forth between him and Brian Albert and Chief Berkowitz. Quote, you have a 3-minute call from or with Berkowitz at 7:22 in the morning. This is on January 29th. Another call with him then you have a call with Brian Albert that afternoon for 12 minutes. Another call with him for 6 minutes. Another call for a minute. Then another call with Albert for 10 minutes. Then a call with Berkowitz for 4 minutes. Higgins spoke with Berkowitz on January 29th, someone who was conflicted out of the investigation 4 times. And then they spoke many additional times between January 29th and February 4.
But Higgins had nothing to do with the investigation, correct?
He was a witness in the investigation.
Okay, at that point,
We have a chief of police who's supposedly...
I'm sorry, I just need to, so at that point you say he was a witness?
I'm sorry?
At that point, the point of the phone calls, he was a witness?
Yes, he was in the home, Your Honor.
Okay.
He was not spoken to by investigators yet, but clearly he's a witness. He was at the home that night. Now, recall that Chief Berkowitz supposedly found a piece of taillight on Brian Albert's lawn on February 4th. After that lawn had been searched by trained investigators and other police officers multiple times without finding it, but somehow Chief Berkowitz was able to spot that piece of taillight while he was driving past the property from his moving vehicle. And the phone records show that Berkowitz called Higgins that very day to tell him about the discovery, and then Higgins calls Brian Albert to tell him. In a case where we are alleging as part of our defense that there is a third-party culprit, and at least some people are involved in a conspiracy to cover up the guilt of that third-party culprit or culprits, contact between co-conspirators could not be more relevant. Before the feds got involved, we fought for this information, but we were largely unsuccessful. Although we never had to prove that the phone records actually contained evidence of the conspiracy. That's something we couldn't do without having the records themselves. This court has previously ruled that it was all too speculative. Not anymore. Not now. Not after we know that the records exist. Not after we know they prove what we suspected that they would prove. We now know that those records will tell a story that could not be more relevant to this case and to our defense. And the problem, Your Honor, is we know the records are there. We have them in summary fashion, but we don't have them in admissible form. The feds have revealed that they exist. but they haven't released the actual records to us. They have them, we don't have them. That's why we're filing this Rule 17 motion. And again, we've more than met the requirements of Lampron. These records are relevant to our defense because they show suspicious contact between parties we allege to be in a conspiracy. They're relevant because they show the Canton police chief inserting himself into a case when it was previously determined that he was conflicted out. They are relevant because they impeach the credibility of Commonwealth witnesses who denied talking to each other, yet have no explanation for these records, which again, do not lie. We cannot get the records any other way. We cannot effectively prepare for trial without these records. The Commonwealth could have gotten them, but they chose not to. They fought our efforts to get them. But again, thank God, another law enforcement agency stepped in and did what the DA should have done. Going to trial without these records would violate my client's due process rights. And finally, to the extent that this court previously ruled that our requests were a fishing expedition, we can't maintain that now with a straight face. We now have the receipts. It's confirmed we were never on a fishing expedition. We were merely on an expedition to obtain relevant material and exculpatory evidence, and we're simply on a mission to defend our client. And I would ask the court to allow this motion.
All right. Thank you very much. Mr. Lally?
So, Your Honor, the Commonwealth does not object to this motion. The only question or clarification that I'd ask for is there seems to be a discrepancy in the dates that I'm not really finding any support for within the context of the motion. So
that's why I asked. So
my question was a different one as to the dates, though. So when it directed towards individual people, it's a time period beginning on January 29th. When it's directed towards the cell phone carriers or providers, it begins with a period on January 28th, which is the day prior to anything occurring. So I'm not sure why anything on the 28th has any relevancy. There's nothing in the motion that I can glean that indicates that. I don't know if it's a Scrivener's error or if there's some other reason for that period for those providers to be starting a day early.
What do you say about that, Mr. Yannetti? Your affidavit says the 29th.
Right. I would orally amend that to the 29th, Your Honor. We're fine with that.
All right. I'm going to hear from the third party counsel if they want to be heard.
Your Honor, if I may, just one further thing. I did speak with counsel. It's attorney Kenneth Anderson, who represents Mr. Berkowitz. There's no objection on behalf of his client.
Okay, thank you. All right, so Mr. Conley?
Yes, thank you, Your Honor. Your Honor, with respect to our general arguments, we'll just rest on I'll rest on what I said previously. And we respect the parties' positions. I just want to point out one thing with respect to the factual assertion. I don't have the privilege of seeing the grand jury testimony, but I can represent to the court that before my client ever testified at the grand jury, he voluntarily appeared for an interview with the U.S. Attorney's Office. I attended that interview, and at that interview, he volunteered to the U.S. Attorney's Office that on that morning he spoke to both Albert and Berkowitz. He was not asked and did not give a rundown of how many times, but he acknowledged long before he testified at the grand jury that he did speak with both of them that day. I don't think that impacts the substance of the arguments, but I just wanted to note that for the record.
Okay, so just so I'm clear, the Commonwealth hasn't objected to these records for that period of time that appears to be a relevant time period.
And so I will waive argument on that, Your Honor.
All right, and does counsel object to these records? Mr. Henning on behalf of Brian Albert. All right, and counsel on behalf of, oh, that doesn't concern you. Okay. All right. Thank you. Defendant filed, Mr. Yannetti, you filed a motion that I just got as I was walking out here.
Right. We're not asking to be heard on that motion. I had alerted your clerk that it would be coming. It's filed with a motion to impound as well. I figured I would hand deliver it today.
Okay,
the
great.
Commonwealth just got it today, so they'll need time to assess that.
All right. So today, all pre-trial non-evidentiary motions have to be filed pursuant to the order.
Yes.
All right. So this is it. This is what
I expect by the end of the business today, the court will be receiving a motion to dismiss to be heard next week as well.
All right, and you can't be here next week.
I cannot, and on that point, Your Honor, I think the court probably was alerted that we filed a second motion to admit counsel from California, Pro Hoc Vice. I don't know that it's necessary, but
I'm glad you filed it because I think it is. If you're not here and you have to be here
that's
for
why
that.
we did.
So
That's why we did that. So,
Ms. Yannetti will. I'll allow that motion now that you have filed your appearance.
Thank you so much.
Okay. All right. So you expect that there will be more motions coming today?
I expect there'll be one additional motion coming today.
All right. Does the Commonwealth have anything that it expects to be filing by the end of today?
Your Honor, just filed a motion for reciprocal discovery, not asking for any action on it, but I believe that would be it.
Okay. And I have one question. Are we all done with Bodie Labs? Have you received the information from them?
So on one part of the testing, yes.
Okay.
On the second piece of the testing, no.
All right. So I need a report on that orally on Tuesday.
Sure.
Where we are with that. All right. Great. I'll see everyone Tuesday. Thank you.
Your Honor. Thank you, Your Honor.
March 26, 9 a.m. hearing on all pretrial non-evidentiary motions.
All right. All right, Brian, we have a 3 o'clock list.
Tuesday at 9 a.m.?
I'll come in and let you know what's left on the list.
Okay, thank you.
You are muted.
So,
The Duarte one, attorney can't, she asked for Zoom, but now she can't do it, so we're in good shape.
sorry, lack of sleep.
Goodbye.
So Tuesday at 9 a.m. Should be all the final stuff because everything else is due today. By end of the day. Yeah, she never releases it. 13 butt dolls. There are a lot of butt dolls. Alleged butt dolls. So the big thing today. Turn this down some. The big thing today is the hearing the Rule 17 motions, of course. So the thing about those, the kind of the core of the defense theory. Oh, not Siri. I said theory. Go away, Siri. No, go away. She thought I was talking to her. The whole core of their defense is the third-party culpability, right? So their theory is that there was this fight and the family, is in on this, covering it up and using their connections to protect the family. So they're wanting these records, like the phone records and stuff, so that they can the Commonwealth says it's a fishing expedition, that they're looking, to see if they can find something, to kind of create something around it. And defense is now saying, okay, now there's no question of us looking, fishing for something, that now we know that they were talking, and they're bringing up the conflicting statements from before about, oh, well, no, I was asleep. And then, oh, well, no, I wasn't asleep. I was being intimate and butt dolled or whatever dolls when you're, anyway. So, again, with conflicting stories and, hey, Bob. Hi. It's an investigation by the defense. So, when they're calling it the fishing expedition, Bob, you want to? Oh, I don't think I have a link. Maybe I do. I'm on Streamlabs. Let me see if I can do it. me mute them. They're saying that you can't call it a fishing expedition anymore because now they know that these conversations happened and that there's been conflicting stuff in the grand jury, and that goes with their third-party culpability. So they're saying this is now proven to be relevant to our defense, and we need to get this stuff. I'm going to see. Bob, you want to come on if I can get you a link? I'm not on StreamYard. I'm on Streamlabs, but I bet I can figure out how to do it. Let me see. The legal part of it. If I can get this going. Yeah, did you see how red my face turned during the intimacy butt dial conversation? Let's see if I can invite. I can figure out how to get Bob on here without using Streamlabs or StreamYard. I can figure it out. Being a technical genius and everything. That camera guy sure does love Zoom. Love zooming right on in. All right, Bob, I sent you a link. Yeah, technical goddess. I've never had anybody on, like anytime I've had anybody on, I've always used StreamYard. So we're gonna see if we can do it with Streamlabs. See how it goes. See if it works. Because if we can get it to work, then we'll have Bob explain the legal part of it. He probably works for Feet Finders. What trial was that where we were watching? Oh, where they kept having the Feet Finders. Okay. All right, I sent that. We'll see. If it doesn't work, then maybe we'll try again. I have so many problems with StreamYard, so I started using Streamlabs. We need an emoji for butt dolls. What is the position of the O'Keefe family? Do they believe Karen? know. You know, the thing that's kind of hard about all of that is you want so badly for the family. How do I say this? More than anything, you want justice for the family. You know what I mean? But it's hard when there are different theories about. Oh, yes. I think I got it. Hi. See if this
Am I on?
Hi, you're on.
I don't see Brandi. Is it just me? Am I the only one in here?
I have you. Can you see me? I can't use my camera on here because I have you on here. Can you hear me? Can you hear me? Oops. Oops. Can you hear me? No? Hold on. Let me see what I can do. Do you hear me?
Is Brandi here?
Do you hear
Can't
me?
tell if I'm on or not. It says I'm in. Says I'm in the show.
I hear you.
Hold on. Let me go grab my phone.
We'll figure it out. It'll be fine. It'll be fine. Maybe. See if this works. Let's see if it works. I hear him.
All right. So am I on?
Yeah.
Like I can't hear you. I can't see you
Oh.
at all if I'm on.
I hear you. You don't hear me?
Oh yeah, I'm on, but I can't see you, Brandi. If you can hear me, can you all hear me?
Well, I can hear you.
I can't see the chat because I came through StreamYard. All right. So am I on?
Yeah.
I can't see you at all. If I'm on. I mean, I can see. I'm watching you on my phone, so I can see you there. It's weird.
I can try to do. I can send you a Zoom link, maybe. Because I'm on Streamlabs instead of StreamYard. Now I can't hear. Let me just start a new stream, and I'll start it in StreamYard. Let me do this. Let me do this. Because I don't know if I'm able to do... Let's see if I can do this. Oops. All right. YouTube. Okay, here, I'm gonna put the link in here. We're just gonna start a new stream so I can use Streamlabs because or StreamYard. All right, here, everybody click on that one. Go over to that one and I'll see you there. Let me set it up to portal just in case. I'm coming, Bob.